Mr. Chief Justice, may it please the court. Many years ago, my co-counselor and I shared a nursery school class together. It was a long time ago, and I don't really remember much, but I remember I learned a few things. I remember how to bless the hollow and the wine, I learned how to tie my shoes, I learned how to share with my classmates. But there was one thing that I did learn that stuck with me throughout my entire life, and it's the most important thing that I've ever learned, and that's right from wrong. From age 4, actually, forget age 4, from the moment we are born, we learn the difference between right and wrong, how to make decisions between what is morally correct and what is morally incorrect. At age 18, we do not first learn what is right and wrong, but rather it is instilled within us for our entire life. And might I add, I have a source on this subject. He isn't a medical professional, but he does have some experience on the matter. I like to quote, "They do know the difference between right and wrong." Donald Zeltzer, attorney at law. Now, I remember back in nursery school when we did have these issues with behavior, as me and my co-counselor did have from time to time. We were punished. But this punishment served two purposes, both to teach us that we were wrong and to punish us for that wrongdoing, but also to prevent that from ever happening again. Now, in today's big boy words, I use that as retribution and deterrence, which are similarly the two causes for the punishment of the death penalty. It does not require an adult to know right from wrong, but rather an individual. Yes, Amina, you may speak.
All right.
I mean, Justice Razak.
All right, thank you. So first you said that you learned at your nursery school the difference between right and wrong, correct?
Yes.
So this is at a young age, but that was because your environment taught you to learn the difference between right or wrong. What if you never were taught this difference between right and wrong? How would you, if you grew up in a bad environment, how would you possibly understand this?
Okay, so you're pretty much just saying that we need to consider more things than just a person's guilt or innocence, right? There must be something in our judicial system that takes that into consideration, right? Okay, so we have mitigating and aggravating factors. And we have two different types of trials. In our first trial, you're well aware of this, but for those interest groups that might not be aware, I must say that in our first trial, we determine the guilt or innocence of the accused. And then in our second trial, we consider all these other aspects. Now, for those that might have excessive mitigating circumstances, a heavy penalty such as the death penalty will be considered and would not be taken lightly, whereas those who have had the opportunity to learn right from wrong in wonderful nursery classes, such as mine and my co-counselors, they would be held responsible. Yes, Mr. Chief Justice.
You said that you grew up and you were taught these things.
Yes.
And Sabina said that there are kids like Kevin Stanford who grew up in a neighborhood where their father abandoned them. They were introduced to alcohol at a young age. What can you say to these people? Because he was obviously, as you know, put on the death row. So how can you say that the aggravating and mitigating circumstance they work when he was put on trial and given the death penalty when he had a lot of these aggravating and mitigating circumstances?
Well, so you're saying how all these mitigating circumstances, they all, like his abuse, his sexual assault, all these different things, they all sort of bottled up and they just culminated in this one moment where he just lost it, correct? And that should be considered?
Yes.
I must add that the petitioner was actually regularly recruited for these events and was robbing on a regular basis. So this was not one thing that he did one time, but was rather a career criminal. Now, Justice Shockey?
Mr. Staloff, a few moments ago, I recall you saying that the punishments, the very rare punishments, I'm sure, that you endured as a child at your wonderful nursery school, were the purpose of these punishments was to teach us right from wrong.
Yes.
Now, how do you propose teaching a juvenile right from wrong while you kill him?
Well, that would be the deterrence argument. And the deterrence wouldn't necessarily teach the defendant what right from wrong is, but would teach other potential juvenile murderers what the difference is from right from wrong and would deter other potential criminals from killing in the future or doing other such heinous crimes. Now, Justice Gonzalez.
Overall, wouldn't you say that rehabilitation for minors, as opposed to this retribution and deterrence, would be a more economical and morally conscionable alternative to the juvenile death penalty?
Rehabilitation?
Yes.
Okay, might I add, one of our opponent's statistics yesterday clarified that approximately, actually over a third of the people who are put into rehabilitation, after they are released within 2 years, approximately 35% are sent to jail again for another crime. So clearly rehabilitation is not as much of a promising alternative as it may seem. Now, might I add, the wonderful Val Zeltzer focus on a neurological standpoint, so might I go into brain development. When someone turns into the adolescent age, something called gray matter is produced, and it is produced at the highest rate it has ever produced in its entire lifetime. Now, the petitioners focus on prefrontal cortex. The gray matter is the part of the brain that does the thinking. And at its highest rate in its entire lifetime, this gray matter is being produced. So the ability to make decisions is being developed at its highest rate ever. Now, might I also add that immediately after the gray matter is produced, it is covered in something called myelin, which is a process called myelination. This is a fatty tissue that helps speed up these connections. So not only is the framework for being able to make decisions being made, but also a framework for being able to make decisions quickly are also being made. The decisions between right and wrong will be made quickly. Okay, you may please go on.
Okay, so I'm just going to make a correlation right now really quickly for
Sure.
the sake of making the points. All right, so let's consider abortion. So because we don't know exactly when life begins, some people argue that it's wrong to abort a pregnancy. But because we don't know exactly when each individual's human mind develops into the adult mind, can we argue that it's unconstitutional to kill 16 or 17-year-olds whose minds may not be fully developed?
I'd like to point out that at the age 16, adolescents are first able to make decisions based on their own medical needs. Now, if they can make decisions based on their own life and death, I believe that they're responsible enough to make decisions based on the life and death of others. Now I turn the floor over to my co-counselor.
A rule categorically exempting 16 and 17-year-olds from the death penalty, no matter how crazy or sinister the plot, would be arbitrary and not be the proper solution. Juvenile defendants, even those in the same age group, are shaped by individual life experiences and therefore possess different levels of maturity and make different life choices. Therefore, we should leave juries the responsibility of determining the culpability of individual defendants. This should be done on a case-by-case basis, based on the nature of the crime, the maturity level of the juvenile defendant, and many other factors. A person who is 17 years old and, let's say, 364 days can be just as culpable as someone who is, let's say, 18 years old and 5 days. So many 16 and 17-year-old killers are certainly able to distinguish right from wrong and know of the consequences of their actions. Yes?
Yesterday someone brought up about them being judged by a jury of their peers.
Yes.
Do you believe they should be allowed to be judged by a jury of their peers or no?
I think being judged by a jury of their peers is certainly an option. I think we should take into account all these factors such as their historical background, their criminal record, these aggregating and mitigating circumstances to judge whether the death penalty is the right solution, because obviously in all cases it isn't, but we should judge whether to apply it, and sometimes these circumstances can lead to
How does the respondents oppose the court distinguish between those who've been afforded the opportunities to learn right from wrong and those who haven't?
Yeah, well, like I was saying before, we need to judge on a totality of the facts and all these different circumstances that they had. You know, we know that some people don't come from the same backgrounds as others, and some people learn right from wrong a different way than others. So we need to judge based on these aggravating and mitigating circumstances whether or not the death penalty be applied or some other punishment be applied. Yes.
Counselor,
Yes.
as you stated that we should judge it on a case-by-case basis
Yes.
based on state as well, how do you propose that the federal government and the court that you stand before make sure that no state abuses the power that we are giving them? The death penalty is the most final act any court can give out. So how would you propose that should we monitor the fact that states should not abuse it, or should we say that it is up to the states to decide what they should do?
Well, based on the numbers of juveniles executed in the last 30 years, we know that it isn't being abused. And it is being used in a way that, I mean, we're really only punishing the worst and the most heinous of crimes. So I feel like the way it's being used now and being applied is the perfect way to go.
Excuse me? 89% of Americans live in states that have not executed a juvenile in more than a decade. Doesn't this mean that the juvenile death penalty is actually outdated?
Well, according to studies by the American Bar Association, 30% of America favors the juvenile death penalty.